Welcome back, Ryan Brown of J. Ryan Brown Law in Noonan, Georgia here, and today we're going to talk about 6 changes to the Georgia Child Abuse Registry laws that went into effect in Georgia on January 1st. The Child Abuse Registry is a central database maintained by the state government where people who are substantiated, is the word they use, by DFACS are placed onto a registry and their names are maintained there. The first change that went into effect this year, that's an important one and a step in the right direction, is that only adults may be placed on the registry now. Before January 1st, minors 13 and up could be placed on the registry, and now it is only for adults, which is a step in the right direction. Second, and this is a big one, before this year, the process was that if DFACS substantiated a case, substantiate is the buzzword that they use, then a person's name would be placed on the registry and you had to petition to be removed from the registry. This year, there's an important change where if DFACS makes the case, you have the right to appeal before your name is actually included. So it used to be a petition for removal from the registry, the Child Abuse Registry, and now it's more like a petition to prevent your name from being placed on the registry. Another big one. In the past, you only had 10 days to file your appeal. 10 days. That is so quick. When you're talking about someone who gets something in the mail, something they may not have been expecting, they need to find counsel most likely or represent themselves. But many people are reaching out for counsel and then get the appeal in within 10 days. That is an incredibly quick turnaround time. The new law provides for 30 days. It's still fast, it's still quick, but it really provides an extra 3 weeks or so for someone to seek out and find a counsel of their choice, attorney of their choice, or make an intelligent decision to represent themselves. I think that it is wise to have counsel for this, but it at least gives people time to reflect and make an informed decision about that. Another interesting fact, and my practice is entirely either criminal defense or quasi-criminal, and I consider this sort of a quasi-criminal matter, the Child Abuse Registry. The new law gives the district attorney, the prosecutor, a statutory right to request that the case be continued and beyond the conclusion of the criminal case. That doesn't mean that the judge has to continue it, but the DA now will receive notice and actually be able to file a motion with the court. I think they have 20 days, I believe it is, from receipt of the notice to request that the administrative courts continue these hearings. A lot of times they do that because the prosecutors don't want us questioning their witnesses. The prosecutors may be afraid of what the witnesses will say, or they don't want to create extra testimony beforehand. So the DA now has the right to request that the registry hearings be delayed. There is now also a provision that allows for expungement from the registry. It takes 3 years. Someone has to be on the registry for 3 years before they're eligible for the expungement, but that is certainly interesting. The sixth and final update or statutory change is there. In these cases, it's always prudent for counsel to subpoena and try to obtain DFACS records, as that is what the department is relying on in these matters, and it's really the petitioner's only chance to get good information. Well, the new law, the reworked law, provides a statutory provision that specifically applies without getting too technical, it is now explicit that counsel for petitioner, the person trying to get off the registry, can access those DFACS records. So it applies OCGA 49541 to child abuse registry hearings, which in my experience has not been too litigated here locally in the Coweta circuit, but that doesn't mean that it's not in other places across the state. So that is good. It makes sure that we are really using the courts for truth-finding process and are working to find that. So those are the big 6 changes to the Child Abuse Registry. It's easier to subpoena DFACS records. You can be expunged after 3 years now. The DA has statutory rights. The time for appeal has changed from 10 days to 30 days. You can prevent yourself from being placed on the registry instead of just automatically being placed now. And now the registry is only for adults. 6 big changes to the Child Abuse Registry. I hope everyone found that helpful. I'm Ryan Brown of J. Ryan Brown Law. We are located in downtown Noonan, and we look forward to hearing from you.